during the lifetime of the father, my lord, children could not have filed the suit.
Correct.
Now my father died, my lord.
When?
He died during the pendence of the suit itself, my lord. That was not at all the ground. Under order, what they say is there is a will in their favor. So when there is a will, my lord, property belongs to the mother. On that ground, my lord, the trial judge, the application was filed.
Let us assume
Yes,
mother's will is not proved.
yes,
Then also the
Yes.
property would devolve upon Balasubramaniam and Janaki,
yes,
even in the absence of will.
yes, yes.
And he executed a relinquishment deed.
That is that children, my lord, now we dispute.
He did not question it during his lifetime.
Yeah, he did not question.
So by the time he died,
Yes,
his right to question it had expired because of law of limitation.
maybe,
So
but
so the children did not inherit the right to sue.
But that is not the ground taken, my lord. That our mother had executed a will. There is also a gift deed. So on that ground, my lord, property belongs to us. It is an absolute property. We have no right.
Correct. Just a second. The property belonged to your mother. Sorry, grandmother Saraswati.
Yes,
There ends the matter.
yes,
Because when the suit was filed,
yes.
son was alive, daughter was alive.
Yeah, father had a right.
No, father had no right.
No, he could have challenged the gift deed.
Didn't challenge.
He didn't challenge. That is another aspect. He didn't challenge. The trial judge may be right, but in view of the subsequent fact, admittedly, my lord, my father had a right to seek for a declaration and partition. My lord. Now my father is no more, so the right to sue, my lord, as far as the children are concerned, my lord, it will survive.
Where is genealogy?
Genealogy, my lord, if your
Right.
lordship may kindly see, my lord, the appellant, my lord, is the appellant 1 and 2 are the sons of the first defendant.
Mother's property,
Property belonged to Saraswati.
Saraswati,
Yes,
mother. And she has executed a will and thereafter her
yes.
defendant number 1 have executed
Yes,
a
yes.
release deed.
Just a second.
That is not
Just a
disputed.
second. When
Yes.
Saraswati died?
1997.
She has got one son and one daughter.
But she died on 1997,
Yes.
11 to 1997.
All right. One son and one daughter.
One son and one daughter.
Ah.
And my lord, the son have executed a release deed. That is also admitted
In favor of?
in favor of the second defendant. The first defendant have executed release deed in favor of second defendant.
Agbat sir, genealogy and everybody. See, Saraswati died in 97. He is survived by Balasubramaniam.
Balasubramaniam and
Janaki.
Lord, the
second defendant.
second
Janaki.
defendant.
Janaki.
Yes, my lord. Janaki
So
Natarajan.
one son and one daughter.
One son and one daughter.
Son executes a release deed in favor
Yeah,
of
release deed in favor of second defendant. That is Janaki. Janaki.
Janaki. also.
Janaki.
Ah,
The
So-
plaintiffs are the sons of
yes.
the first defendant.
All right.
The
Now who died? Now,
dependency-
who died? Who died?
Our father, my lord, first defendant.
Ah.
So first defendant,
When he
yes,
executed the release deed?
2007, my lord.
2007.
Yes.
He has not
No,
disputed.
that is disputed, man. That the children dispute, my lord.
Children are disputing during
yes.
his lifetime. He has
No,
never done.
now, see, under order 7, now, my lord, my suit, my lord, came to be dismissed on the ground, my lord, on the question of law, my lord. Order 7, Rule 11, DL. Now, what the court says is, during the lifetime of the father, my lord, children could not have filed the suit.
Correct.
Now my father died, my lord.
When?
He died during the pendence of the suit itself, my lord. That was not brought to the notice. He died during the pendence of the suit. So whatever, my lord, he had a right, my lord.
He had, just a second. He
Yes.
had a right to question the.
Yes,
Just a
gift
second.
deed as well as the,
Just a second.
Yes.
He had a right to question the relinquishment deed
yes,
within 3 years from the date of execution of the deed.
yes,
It was executed in 2007.
yes,
He died during the pendency of the suit. That is, after 2016.
yes,
Within 3 years, he has not questioned it.
it is not questioned,
By
but,
Just a
but,
second. By the time he died, right to sue or right to question the release deed had expired. So you
But
have not
that-
inherited that right.
no, but that was not the ground, my lord, taken by them. That was not at all the ground. Under order, what they say is, there is a will in their favor. So when there is a will, my lord, property belongs to the mother. On that ground, my lord, the trial judge, the application was filed.
Let us assume
Yes,
mother's will is not proved.
yes,
Then also the
Yes.
property would devolve upon Balasubramaniam and Janaki,
yes,
even in the absence of will.
yes, yes,
And he executed a relinquishment deed.
That is, that children, my lord, now we dispute.
He did not question it during his lifetime.
Yeah, he did not question.
So by the time he died,
Yes,
his right to question it had expired because of law of limitation.
maybe,
So the
but
children,
yes.
so the children did not inherit the right to sue.
But that is not the ground taken, my lord. That is, your lordship may kindly see order 7 rule 11, application filed by them, my lord. Lordship, what they say is, our mother had executed a will. There is also a gift deed. So on that ground, my lord, property belongs to us. It is an absolute property. We have no right.
Correct.
No, that is a
No,
that's
With will, without will, the same would be.
no, that's a question of trial, my lord. My suit cannot be dismissed at the threshold, my lord. Kindly see my plaint. Your lordship may kindly see the plaint, my lord. That cannot
Sir,
be a ground, my
No
lord.
locus to file a suit.
At that,
that means-
at the relevant point of
That
time.
means you had no
Yes.
cause of action to file a suit.
Yes, I should have a cause of action. Without cause of action, I can never file a suit, my lord.
You
But
might have
in
shown
the-
a cause of action, but not a cause of action in the eye of law.
No, but maybe, my lord, but that was not the point which was urged by
That's
the.
That is the point.
No, kindly see the application. That's why, my lord, I would like to, I request your lordships kindly to go through the applications filed by them, my lord. What they say is, they don't say that we had no right at all. What they say is, there is a will. There is a gift deed. So you have no right to claim,
Now forget about their application.
yes.
You look into your plaint. It's order 7 rule.
But that would be a new case, my lord, set up. My lord. That would be a new case.
No, order 7 rule 11
Yes,
is only based on your government in the plaint.
yes, the trial court has to decide that point, my
No,
lord.
if the plaint government says.
Yes,
the
that,
property- Just a second, the property belonged to your mother, sorry, grandmother Saraswati.
yes,
That ends the matter.
yes,
Because when the suit was filed,
yes.
son was alive, daughter was alive.
Yeah, yes. Now, in view of the death of the father, my lord, now father died, my lord. Father died during the pendency of the suit. He died, my lord. So the trial judge, what the trial judge says, and the
Father is
second,
not the plaintiff.
he was not the plaintiff, he was the defendant. Yes,
Father is the plaintiff.
But-
He could have,
yes, but father had a right, my lord. Father had a right.
no, father had no right.
No, he could have challenged the gift deed.
Didn't challenge.
He didn't challenge. He did. That's another aspect. He didn't challenge. But the question is, my lord, whether these facts were pleaded. The trial judge has dismissed on a different footing, my lord. This is a,
Now
this,
go by your plaint government.
no,
plaint
yes,
government
that
would-
is there, my lord. That I can't dispute the plaint. Everything is in black and white, my lord. I can't. But the proposition,
Once you admit that Saraswati was the owner of the property.
yes,
And once you admit that when you filed the suit, your father was alive
yes.
and your aunt was alive, there ends the matter. You have no cause of action in the eye of law. to
At
file
the, at that point of time, I had no. Yes, that I admit, my, because the trial court, my lord, has exactly rejected my plaint on that ground only. But in,
that event, there is no scope for interference for us. Now. If you have got a separate cause of action on the premise that succession is opened after death of the father, you work out your remedy by filing a fresh suit if it is permissible.
no, that can be noted, my lord.
We won't say
Allah.
that you are entitled to file a
No,
suit.
legal, no, on the question of law, otherwise, but I may be permitted to file a suit, my lord.
What we
Otherwise,
says, if there is a fresh cause of action, it is for you to work out your remedy. That's all. Because of the death. which
yeah,
is-
yes, my lord.
Blood,
Because-
As your lordship have rightly pointed out, my lord, the release deed was dated 7/1/2015.
15.
And my lord, his father was alive till 2024. And my lord, till 24, he has not filed the suit. Now, my lord, once he has not, he is accused of his rights also,
Second.
because he was
Second.
placed ex parte here.
In the written statement, oh, he was placed expert in that.
He was placed ex parte here. It was a collusive suit between them.
Father.
He was placed ex parte.
Father,
Defendant
not
was
you.
placed ex
You-
parte.
They,
So,
No, we won't say that he is entitled to file a separate suit. We can only say that.
like, if that much observation is given, my lord, definitely they will file, my lord, because, my lord, the learned trial judge have not even, my lord, Article 7 Rule 11D application, Hakiradukku, and this, my lord, there is the learned trial judge have observed only the averments of the plaint and have rightly rejected the plaint. So therefore, my lord, as on the date of filing of the suit, there was no cause of action, therefore the suit was rejected. If that is sufficient, my lord, rest if they have got work out, my lord, without any observation, my lord, it flows, it goes without saying, my lord. If they have a cause of action, my lord, because otherwise also, in that case, I'll not be entitled to say, take here, the same contention.
Whether we observe or not, he is going to file a suit.
Definitely. Even if it is not observed, it will be filed. There, if that observation comes here, I'll not be able to file Article 7 Rule 11D again there. Because that, my lord, he will always say,
We can say, if the appellant claims, because he has raised a contention now, we have to answer that. If the appellant claims that succession has opened again, then it is for him to establish. Yes,
it's for him to establish. But let there not be any observation in this suit.
no, he-
not permit him, that's all. will not, there is no express permission to be granted by this court.
Yes.
It's for him to work out.
Because he can't shut
But
out
the learned counsel
on both the
appearing for
stages, my lord.
appellant and the respondent. Full stop.
No, may I just
The
submit my-
plaintiffs are before this
Yes.
court.
Para 25 of the trial court judgment, my lord. Their claim was allowed only on the ground that I had no right, my lord. Section 15 was quoted, my lord. Court says, my lord, I had no right at all. The trial judge, in fact, maybe it was a mistake on our part. We should have brought to the notice the death of our father. Probably we didn't bring it. But the fact remains, my lord, he was dead at that point of time. So succession opens. So, my lord, a liberty may be granted to
No, no.
file a suit.
However, it is to be noticed that defendant number 1 died in the year 2024, full stop. The learned counsel for the plaintiff submits that the succession has opened in favor of the plaintiffs after the death of the father. As such, the suit is maintainable. Learned counsel for the respondent would submit that the release deed was executed by defendant number 1 in the year 2015 and he died in the year 2024. At the most, he could have questioned the release deed within 3 years from the date of execution. As such, he had lost the right to challenge the relinquishment deed. As such, the plaintiffs cannot question the relinquishment deed, full stop. Since this is the development which has taken place during the pendency of the suit, this court is not going to express any opinion on the claim of the plaintiffs relating to succession being opened after the demise of the father of the plaintiffs. If any action is brought subsequent to the action is brought by the plaintiffs on account of death of defendant number 1, it is for the court to take appropriate, it is for the court to pass appropriate orders in accordance with law. Appeal is dismissed.
Yes.